Good morning, everyone, and welcome to the 31st Annual Thrower Symposium. My name is Daniel Reach, and I am the Editor-in-Chief of the Emory Law Journal. Today's symposium will cover innovation and the law. Innovation in any era brings with it its challenges and its opportunities. But in recent times in particular, the stunning pace of breakthroughs in technology, business, and social interaction present new opportunities for an analysis of law's role in fostering innovation. Our keynote speaker, as well as our moderators and panelists, will explore various aspects of this interaction for you today. It is our hope that you will find this discussion enlightening and that the event will open a broader debate and provide a source of reflection on the issues that arise as a result of this intersection between innovation and the law. As is tradition, the debates, discussions, and ideas presented today will manifest themselves in printed form as part of the Thrower Symposium issue. This year in particular is a special one for the publication side of the Thrower Symposium, and that is because our previous 5 issues of our Thrower Symposium are now in compiled form as part of the Thrower collection. At this time, I would like to take the opportunity both to extend my deepest thanks to the Thrower family for their continued support of the symposium, as well as to present to them this compilation of the Thrower Symposium issues. Mr. Wilson Barmeyer, please accept this compilation from the Emory Law Journal, as well as our thanks. Once again, I'd like to thank the Thrower family, as well as the Thrower Committee, for their support and guidance throughout the year. I'd also like to extend a special thanks to Brooke Suttle, our Executive Symposium Editor, for bringing together such a fine grouping of panelists today. I'd like to thank Meredith Malmers, our Symposium Editor, as well as all of the 2Ls on the Emory Law Journal for their support in putting together this symposium. To the staff of the Emory Law School, particularly Amy Tozer, Wendy Cromwell, Eric Blackwell, and Rhonda Heermans, I extend my deepest thanks. And to the faculty of the Emory Law School, in particular, Professors Busby, Shaner, Seaman, Holbrook, Audier, and Vertinsky, our deepest thanks. We could not have put this together without your help. Thank you for coming, and we hope you all enjoy the symposium. At this time, I'd like to welcome the Dean of Emory Law School, Mr. Robert Shapiro.
Well, I'd like to welcome all of you to the 31st Annual Randolph W. Thrower Symposium. Academic years have highlights, and each year the Thrower Symposium is a shimmering highlight in the Emory Law School academic calendar. This symposium has been generously endowed by the family of Randolph W. Thrower, and for most of the last 31 years, we've been honored to have Mr. Thrower in attendance. He's not able to be here today, but we are privileged to have his grandson, Wilson Barmeyer, here. And Wilson assured me that he is going to be here all day and absorb all of the proceedings, and then afterwards go and brief his grandfather on the insights and illuminating things that have been learned here today. Also, over the past years, we've been privileged to have Randolph Thrower's daughter, Patricia Barmeyer, here. She, unfortunately, cannot be here today because she is continuing the great family legal tradition by arguing before the United States Court of Appeals for the Fifth Circuit. Now, this symposium has always brought together leading scholars and practitioners from around the world and has addressed cutting-edge issues of law and policy. The organizers, the Emory Law Journal, with the organizing committee, have selected topics of great current significance with long-lasting implications. Recent topics have included the politics of the judiciary, regulation and deregulation, executive power, federalism, family law, and this year's topic, innovation for the modern era, continues this great tradition. Now, in a few moments, we will begin with a sterling lecture by Chief Judge Paul Michel, and then continue with panels on technological innovation, social entrepreneurship, and innovative lawyering. Throughout the day, we will explore the role of law and lawyers in fostering innovation. Now, law is sometimes thought of as a conservative discipline intent on preserving the past rather than on facilitating change. I was reminded of this when from this podium earlier this week, Judge Dorothy Beasley reminded us that this week marks the 200th birthday of Charles Dickens, a man who made famous the stagnating effect of the legal system. Right? Not much innovation in Bleak House. But we know better. At Emory, we understand that law has a very important role in facilitating innovation. For example, through our Tiger program, a technology partnership with Georgia Tech, Emory law students have an opportunity to participate in commercializing and providing intellectual property protection for innovations. And in many other ways as well, at Emory, we focus on the role of law in facilitating new developments. There's really a growing appreciation around the world that the legal system is an essential element in fostering innovation. Developments in science, technology, and communications are, of course, critical. But without the rule of law, without the right set of legal principles, no progress would be possible. At Emory Law School, we seek to advance the rule of law at home and around the globe, and to promote a world in which law provides a common framework for courageous leaders to engage our most complex social and economic challenges and to achieve positive social transformation. And today we address several questions at the core of law's role in promoting positive transformation. What set of legal institutions best facilitates the amazing innovations we have seen and hope to continue to see in the future? Later today, we'll be hearing from our colleague, chemistry professor Dennis Leota. Through his work, Professor Leota and his colleagues have saved millions of lives around the world. How can the law help to facilitate the development of life-saving drugs and ensure their availability? What are the economic drivers underlying innovation, and how can markets best support change? And what is the role of legal education and the legal profession in supporting innovation and encouraging innovative thinking? Well, clearly one thing that law schools can do is to sponsor symposia like this one to engage in critical reflection on these important questions. And so I'd like to add my thanks to all the people who made today possible. Special thanks to the Thrower family, to the organizing committee for the symposium, and to the wonderful students of the Emory Law Journal, especially Editor-in-Chief Danny Reach, the symposium editors Brooke Suttle and Meredith Mommers. One of the greatest contributions Emory can make to positive transformation is through the outstanding students like Danny, Brooks, and Meredith who pass through our doors. So thanks to them for putting this event together, and thanks to all of you for attending. So let's get on with what I'm sure will be a fascinating and illuminating day. Thank you.
Good morning, one and all. For those of you who may not be fully versed on who I am or why I'm here, I'd like to start with that. I just recently concluded 22 years service on the United States Court of Appeals for the Federal Circuit, sometimes known as the Patent Court. And the last 5 years of that service was in the capacity of the Chief Judge of that court, which gave me some extra responsibilities, but more pertinent to today's enterprise, some broader perspectives than I had as simply one of the 16 judges, 12 active and 4 senior judges on that court in that era. I had originally imagined I would stay on the court until I got carried away in a pine box at some advanced age. I loved the work. I enjoyed every single day I was there. I thought I would never leave. So why did I leave? Well, I left because primarily I saw a vacuum, a need, some gaps that cried out for an additional voice in the chorus. And I found that the quite appropriate limitations on what sitting federal judges are permitted to discuss in public to be a bar against filling the need that I saw. And so in order to regain my First Amendment rights, I resigned. So for the last 20 months, I've tried to be a constructive voice, sometimes a nag, sometimes a nuisance, but with the great advantage of being free to speak my mind based on experience and insights that I might have to contribute to the larger debate. So that's what I want to discuss with you this morning. Let me start by just saying how pleased I am to be here. Today is my first visit to Emory Law School. I have a prior association because I sent one of my prized first law clerks, actually my very first law clerk, here for some service years ago as Dean of Students, I think was his title. So even though I hadn't visited, I've heard quite a lot about Emory Law School, and it was all quite good. As an eyewitness, starting at 4 o'clock in the afternoon yesterday, I got to see firsthand just how good Emory is. And of course, it's not so much this magnificent auditorium or the other physical facilities here, but as always is the case, in the end, it's the people who count, the leaders and all the other people, the faculty, the staff, the students, the law journal, and so on. So last night I got a taste not only of a very fine dinner at the Rosebud restaurant, but a taste of how impressive the young men and women attending this school and serving on the Law Review editorial board are. I'm now at the advanced age of 71 years, so I now have a little bit of a different perspective than I did before. And I can hardly express to you the thrilling sense I got at dinner last night talking with some of these young people about the prospects for the future for this country. Because these are exactly that sort of very smart, very ambitious, but well-balanced and nice and thoughtful people that this country needs to be taking over the reins as time moves forward. So my confidence in the future got a big boost last night and this morning, and I think that that is a very welcome thing. I want to thank Dean Shapiro for his generous time last night, joining us at dinner and kicking off the session this morning. It's great to get to know him. Leaders always set the tone, whether they're law school deans or chief judges or CEOs of corporations or whatever, and I think he sets a very good tone here. Serving on the court, one of the great fringe benefits of being a federal judge actually is a well-known secret, and that is the association with law clerks. We have life tenure for law clerks. You might have thought that when they leave after a year or two, they would go off and become prominent professionals and wouldn't have so much to do with us aging judges. But the truth is that they are like family. It's like a growing army of nieces and nephews. You get to know their families, their parents, their boyfriends, girlfriends, spouses, eventually their children. It is a great association, and I've richly enjoyed it. And as a result of that, not only the clerks who served with me personally, but clerks who served other judges on the court become kind of a part of extended family. So, for example, I've had a great time this morning getting a little bit reacquainted with Professor Scott Keefe from George Washington. You'll hear more from and about him later. A law clerk to another judge, and Emory Law School's own Professor Tim Holbrook, another law clerk, not to me, to another judge, but again, it's with immense pride and joy that I see him, and he really is the reason I'm here. One of the secrets about the law clerk-judge relationship is if the law clerk calls up his or her judge anytime and asks for anything, the answer always seems to be yes. So Holbrook called me up, and I said yes, and here I am. Also want to thank Brooks Suttle and his colleagues for an extraordinarily well-orchestrated, well-timed, well-thought-out, well-planned, well-everything management of this event, and particularly the mundane needs for transportation and lodging and so forth of the various visiting persons, including myself. The 31st Symposium, well, that's a great tradition. You know, it's worth pausing just for a second to reflect on the generosity of private actors in our country, people who found enterprises, people who support law schools, people who support all sorts of worthy public activities for the benefit of the broader community, not because they have to, not because there's some requirement, but because part of what makes this country special when it's at its best is this enormous generosity that people of means have, and it drives them to want to share their means with others, just as exemplified by the Thrower family. So it's a great tradition, and I'm sure the 32nd and successive conferences will continue the forward surging good that comes from that sort of generosity. Okay, well, where are we as a country in terms of innovation policy, intellectual property, and so forth? I would submit to you that we are at a very awkward moment poised between the recent enactment of a major revision of the patent laws, the first major revision, it's fair to say, since 1952, so more than half a century, poised between the enactment of that statute and now the proposed regulations to carry out the mandates of the statute on the one hand, and on the other hand, the realities, the hard realities of implementation, and particularly of impacts. What will the practical impacts of implementing the new law be? That's what I'm going to explore with you. Now, I would suggest that you all, we all, in some sense or other, are part of the innovation community because we care, we depend on it, we're part of the intellectual property community to some degree or other, and some people in this audience are full-time patent law professionals. But whatever your exact role is in this larger drama of law and innovation, I think the importance of your contributions are impossible to overstate, and the need for your increased involvement and boldness is also difficult to exaggerate. Why is this? Well, because sensible policy, sensible implementation, carefully calibrated impacts have to be based on knowledge and experience and reason and judgment. So if we compare the relative advantage of the Congress of the United States, its staff, the Supreme Court, its law clerks, the Federal Circuit, its staff and law clerks, people in the Commerce Department, people in the White House, people in other important policy-making agencies of the government, we compare their knowledge with your knowledge. If we had to bet, I would bet on you, because you see it at the practical level as students, as professors, as practitioners, and in your other roles. We know what the Congress can produce. We know what the Patent and Trademark Office can produce, and the related agencies, the Food and Drug Administration, the Customs people, the International Trade Commission, and so forth. And I would suggest that it's modest. I think the new bill has much good in it. I think some things in it are atrocious. There are a lot of things in it hard to categorize until you see the actual impacts in the real world. Then we'll know. And that's really the theme of my talk. What do we do as we see it taking effect, as we can see, evaluate, assess the impacts. So I want to suggest to you that what's most needed is a new approach to watching this unfold, to monitoring these developments. It's an approach that will emphasize some kind of simple forms of assessment. You could almost capture it maybe in a few simple words. Count and measure, evaluate, analyze, and craft useful adjustments. There's no way that the current regime under the new statute and the new regulations will be perfect. Even if the law had been perfectly drafted, the implementation would be far short of perfect because that's real life. That's what always happens. And I think this particular statute was far from perfect as enacted. And the challenges in successfully implementing it are huge. Now, it's ironic, in my opinion, that the America Invents Act was passed with an extensive record of 6 years of hearings that included almost no hard facts or metrics of any kind. To a great extent, it was based on prophecy, assumption, hope, and to a great degree, I'm sorry to say, special pleading for narrow special interests by very, very powerful companies. So there was no assessment at all of the costs, the transaction costs just to get used to a new set of rules, costs that law firms will bear, their clients will bear, costs the government will have to bear. There was no serious assessment of those transaction costs. Nor was there even an attempt to measure the practical impacts on different industries, different technologies, on different institutional players like great universities, like startup companies, like individual inventors, like small entities. Even on the benefits side, there was no careful assessment of how great the benefits would be. There was no magnitude measured. There were not even predictions. Oh yes, in a careless moment, the president said the act would create 200,000 new jobs. Well, it might create a couple thousand jobs for new patent examiners, and it might keep a lot of patent lawyers busier than they already were. But the idea that passing this text somehow magically and promptly creates 200,000 jobs or any other number of jobs, I think is unsound and actually a little bit laughable. So there was no serious effort to measure what job creation effects, if any, it would have and where. Second, there was no attempt to assess how much, or if at all, it would help overall economic growth in this country. There was no, beyond rhetoric, there was no attempt to assess how it would affect our competitive position as a technology leader on the planet. Would it help us retain or regain the top leadership spot or not? There was some talk about that, but there wasn't any serious assessment of it. There's been a lot of talk recently about a revival of manufacturing in this country, of higher technology type of products. But neither did the record before Congress have much of anything about that in it either. So the classical attempt to have a cost-benefit analysis really couldn't even be attempted because there was no assessment of either the costs or the benefits. So the whole thing, basically, in my perhaps jaundiced view, was based on guesswork and on hope. Now, I don't suggest that I have a better crystal ball than anybody else. It's my view that no one, not I, not anyone, can reliably predict the actual effects and impacts, good, bad, and indifferent, of this bill. That's the very reason why you all are so important, because you will be in a position in various individual ways to see those impacts, to see the harms if there are harms, and to measure them. So it's my hope that you will participate in the feedback loop that the country so greatly needs by monitoring, by researching, by reporting, and assessing. Now, the Patent and Trademark Office has been mandated by this statute to file 7 major reports where it's the lead reporters, and 2 other reports, if my count is correct, where other agencies are in the lead, but the Patent Office is to help, and they've already filed a couple of these reports. But we have to be realistic about how much the country and its policymakers can depend on these reports being authored by the Patent and Trademark Office. First of all, there's a huge limitation on the data available to them. Secondly, they have very limited internal capability to do serious research and evaluation and reporting. Third, they have very limited time. Fourth, a very limited number of staffers. I know most of the people doing these reports. Several of them are former law clerks of mine. And they're very smart, diligent people. They're working like crazy. But their capacity is really quite limited. Their expertise is quite limited. And in terms of actual experience, they actually have no experience in doing these kind of reports. So to the extent that Congress is betting all its chips on the feedback loop being these reports being filed and to be filed in the coming months by the Patent Office, I think we're all going to be disappointed. They'll be a help, they'll be worthwhile, they'll be good, but they won't be nearly enough. So there'll be a huge gap, a huge deficit of intellectual input to the policymakers. I don't think anybody can fill it except you and your counterparts, men and women like you, all around this country. Now, why is this so important? I believe that the future of this country depends on many things, of course, but it depends critically, I would even say primarily, on getting innovation right. It will show up in terms of prosperity, income levels for individuals, for families, for companies, for governments at the local level, state level, federal level. It will show up in terms of job creation, desperately needed. It will show up in terms of technological leadership, global competitiveness, and on and on and on. Social cohesion. There's almost no end to the list of major things that are likely to stand or fall heavily, maybe even primarily, on getting innovation right. Of course, getting it right will depend on successful implementation of the new law. It will depend heavily, and this is an area that has been greatly under-attended, on the adequacy of the resources of the implementers. And I'll speak to that in a little more detail, particularly in terms of the Patent Office and the courts, who have been woefully neglected by the Congress for more than a decade and are facing a gigantic mismatch between the actual workload and the actual resources to carry out the workload. And it will depend on future developments and good luck. For example, the beleaguered, nearly dysfunctional Patent Office is struggling with its existing caseload. Some people predict that there will be a tsunami of increased filings by overseas competitors, probably led by China and other Asian countries. So if there is a tidal wave of additional filings, then obviously the delays, the costs, the problems that already are quite bad will get much worse. So I think the question comes down to whether we can develop this feedback loop, whether we can perfect a public-private partnership on innovation policy, not just in the patent law, I mentioned that a lot, but obviously there are broader dimensions to that as well. I don't think it's an exaggeration to say that the very security of the country, we all know about Social Security as a government program, but in its larger meaning, this country, every country, needs Social Security, needs a society where people believe in one another in the institutions where it's perceived as reasonably fair, reasonably efficient, having good potential. So whether you look at it from the social standpoint, the economic standpoint, the technological standpoint, the financial standpoint, getting implementation right, getting innovation policy right is going to drive an awful lot of that, and it will take a lot of luck and a lot of hard work to get it right. Let me start just with employment. In this country, by the year 2018, between today and 2018, we need to create 28 million net new jobs. I'm going to use that phrase a lot, so stick with me on the idea of net new jobs. At present, we're creating something in the order of 200,000 to 400,000 new jobs a month in the good months and less in the bad months. In many months, that doesn't even keep up with the growth in the workforce. So most months, when you read in the newspaper that 223,000 new jobs were created, not really. That's just the increase in the workforce. And it doesn't tell you about the situation of net new jobs, and the same thing with the unemployment statistics. You read it's now 8.6%, and it was 9-point-something percent, so it sounds like, it's really getting much better. But of course, they don't count people who've stopped looking for work. And a large portion of the unemployed have been unemployed for an exceedingly long period of time, longer than any time since the Great Depression in the 1930s. So we need 28 million net new jobs. The best estimates say that there are presently 16 million people unemployed and another 5 to 10 seriously underemployed and needing and looking for full-time rather than part-time work. So the employment problem in this country is enormous and destined to get worse unless we get better. If you look at the broad middle class in this country, for the first time in our country's history, the size of this class is shrinking, and the purchasing power of the average member in the middle class is actually sinking, and it's been steadily, gradually sinking for years. This is not a good trend. This is something that absolutely has to be reversed. We had an experiment, you could say, in this country of offshoring manufacturing jobs. Not only low-tech jobs, but all sorts of manufacturing jobs. We've done it for decades. Some very thoughtful people have assessed, looking backwards, where we are as a result of that. No less a thoughtful analyst than the chief of the Defense Advanced Projects Agency, DARPA, testified before the Congress that from a defense and national security standpoint, the offshoring of manufacturing jobs has been an unmitigated disaster. Why? Because we now don't have the capacity any longer in this country to do many jobs and produce many products that are vital to the military and the intelligence and the other national defense apparatus. And worse than that, she said, it is a she, which is a very good, important thing. She said that it's now clear, maybe it wasn't before, but it's now clear that when you offshore more and more of the manufacturing, before long, some of the designing and intellectual stuff starts to follow it. And because of the separation between the product makers and the product improvers, the improvement cycle starts to slow and falter. So unknowingly, we started to offshore some of our engineering capacity as well as the manufacturing capacity, and that is a very dangerous trend. One of the little-known facts about manufacturing is that there's now some quite good data. You can check it out yourself. I'm not saying take my word for it. that for every factory-type job on the assembly line floor, regardless of exactly what the product is, there are between 10 and 14 other jobs created in the community. All sorts of service people, lawyers and accountants and retailers and so forth. So when you lose a manufacturing job, you don't just lose that job, you lose a whole lot of connected jobs in the community. And so one industrial community after another across this entire country has been hollowed out by this trend. That's why the middle class is shrinking. That's why the economic welfare of middle class people is actually fading. And on top of the offshoring, we're all familiar with corporate downsizing. So again, net new jobs. It may be that GE opens a new factory in Tennessee and is able to brag, quite correctly, that it created 4,000 or whatever the number is of new jobs. But if at the same time it's shrinking other parts of the company by 8,000 jobs, the net new jobs is -4, not +4. So it depends how you count, and it's important, I think, to count realistically. If we look at other countries with high wages, with strong social safety nets, everybody says, well, we can't compete with China because labor there is so cheap and they don't have strong environmental laws, so of course it's hopeless. There's no way we can compete. I think there's actually available proof that that isn't so. First of all, we now are competing with some Chinese-made products, and quite successfully. But more important than that, we can look to other countries for a little bit of a comparison. If you look at Germany, for example, German wages are higher for factory workers than American wages are. German social network, safety net type costs are higher than they are in America. But nevertheless, contrary to us, where we have a negative trade balance of huge proportions, and where we import vastly more than we export, Germany exports much more than it imports, and its economy is booming and has been for years. It manufactures all sorts of advanced products and sells them around the world. So the idea that an advanced country with an aging population and high wages and high taxes and so forth can't compete globally, I would suggest seems to be utterly disproven by the German experience. Now, of course, there are lots of differences. I'm not saying if we just do everything exactly the way the Germans do that we'll have a great revival. But we should look at that. We should take some measure and some heed for that, I think. Now, I suppose that at bottom, what everything depends on is investment. It's just like the students who are here are investing their money, their family's money, borrowed money, however you're doing it. You're investing money in education to build a future for yourself and for families and for the broader community, really for the whole country. So that's just one, of course, little example of an investment. But the country as a whole makes investments. A vast amount of research and development money is funded by the federal government through NIH and other organizations, and the Defense Department and DARPA mentioned previously as well. So investments are the key. Lots of public investments are being made and have been made. But if we look at the future, if we look at the next 10 or 20 years, do any of you here think that given the current deficit problems and national debt problems and the current politics of concern, quite legitimately, I would say, over those financial problems of the country's finances, the annual budget and the total picture, does anybody think that we're going to be able to increase the government investment in research and development and scaling up and developing new products and expanding industry and reviving manufacturing in this country? I don't think there's any chance that will happen. We will be lucky if the public investment in R&D and the rest doesn't stall or even fall. We'll be lucky if it just stays the same, but it's certainly not going up. Now, my premise is we need much larger investment in innovation, in new products, in new companies, much larger. So if it can't come from the government, if the government's fully tapped out, to use the colloquial phrase, which I think it is, then where's it going to come from? Well, it has to come from private sources. There's no other place. It doesn't fall, pennies from heaven. So it's going to have to be private money. Well, what are the recent trends in private investment in R&D? If you go to Silicon Valley and talk to the lawyers there, they will tell you that for the last decade, they've had terrible trouble getting venture capital or other risk capital type money to invest in biotech firms or many other health science related firms. And there are many other industries that report slowdown in the investment of these high-risk capital funds over the last decade. So I conclude from that the current investment incentives are probably not adequate, because if they were adequate, rather than drying up, the flow of that sort of capital would be increasing. And I think it needs to increase. I would think it needs to increase a whole lot and real soon. So if investment incentives are a key part of the solution, if we look at it from that sort of high perspective, what stands in the way? Well, as I suggested, I think, a little bit earlier, one thing that stands in the way is the serious lack of facts, of metrics, of analysis, of input, of feedback to the policymakers who are going to be making the decisions that affect the investment incentives. So there's a kind of an intellectual deficit, I would say. And it's not for want of trying. Lots of you in this room have authored important papers and will in the future, and that's a great contribution and much to be commended, and I praise you for it. But it's not adequate if we measure it from the standpoint of how well informed were the members of Congress when they passed this bill, how well informed were their staffs when they wrote the bill, how able were the staffers and the members to be able to separate out the special pleading based on false assumptions or on self-interest from the legitimate, dependable things also being directed toward those very same people. If they don't have enough background, their ability to separate the wheat from the chaff, inadequate, and that's a problem. The second problem, past the intellectual deficit, is a sort of an institutional deficit. As I mentioned, for more than a decade, the Patent Office has been sorely neglected by the Congress. So, for example, the Congress didn't raise the fees when they needed to be raised because the workload went up hugely throughout the last decade in number and in complexity. And if you measure the combined effect, the workload multiplied by probably a factor of 10 over the course of a decade. As a matter of fact, the Congress not only didn't support the Patent Office by keeping the fee levels adequate, the Congress actually, and now that I'm a former judge I can say this, stole $900 million of private money user fees paid under the compulsion of law, statutory command, by patent applicants, by the companies of this country and individual inventors and universities and all the others who utilize the patent system. So at the very time they should have been providing extra resources to the Patent Office, they were actually siphoning off the private money that's the sole funding mechanism for the operations of the Patent Office. Now, what's not quite so widely known is that the United States courts were equally neglected in exactly the same period in exactly the same way. There is a difference. The courts are funded by taxpayer money, whereas the Patent Office funded in its operational aspects, at least, entirely by private money, user fees. So what we have now, as a result of that congressional neglect, is a patent office and a court system that's way too slow, often makes serious mistakes, way too expensive, and is trapped in a cycle of, it's like the physics force of inertia. It's trapped in bad priorities and bad resources of the past that are stifling what it's trying to do now. Consider the irony. The Congress spent 7 years working on patent reform, which almost exactly coincided with the years that it was neglecting the Patent Office and the courts that have to enforce patents. Patents aren't self-enforcing, and they don't get enforced anywhere except in the court and the International Trade Commission. And so the capacity of the courts and the Trade Commission is a vital part of the investment incentive mechanism. So the neglect of the courts by the Congress is just as dangerous to the future of the country as the neglect of the Patent Office. So once again, it comes back to how do we strengthen this? What is needed? How bad is the problem? And I talked about private funds. You might say, well, wait a minute, we're in a serious long-term recession, so even private money, like government money, isn't going to be very available. But actually, banks, private equity firms, venture capitalists, and other such capital aggregators are sitting on untold trillions of dollars, which they could be investing, but they aren't. And it's not irrational. They see slack demand. They see very poor prospects of making profitable investments and getting a return, so they don't invest. So again, the investment incentives seem to be woefully inadequate. And to tap this private capital, the only kind of capital that's going to be available in the coming decades, those incentives probably need to be strengthened. I don't see how else you can do that without a better, faster, fairer, stronger IP system, particularly patent system, but also trademarks, copyrights, trade secrets, and the rest. How weak is it now? Let me take you on a quick tour of the Patent Office. In the average examination of a patent application, might be a trivial thing like a new version of a Monopoly game, or it might be a life-saving drug, or everything in between, but just whatever it is. Average time for an examination, 3 years. The average is deceptive, because if the invention is important, it's usually more complicated, and there's more difficult analysis needed. So in those cases, usually the delay is far above the average of 3 years. It's very often 4 years, 5 years, 6 years, 7 years. I've seen important patent applications where the examination was not finished until 8, 9, and 10 years after the filing. In the pace of science today, in the pace of business today, in the global competition we're in economically, this kind of delay is absolutely killing our future. It's the worst thing we could possibly be tolerating. Ironically, the average delay in a patent trial in the United States courts is also 3 years, and the exact same analysis follows. In the more important cases, the bigger cases, the more fateful cases for the future of a given technology or company or the whole country, the delays are often 5 years, 7 years, 9 years. We frequently saw cases at the court where the dispute started a decade ago and it still wasn't completely settled. Who owed who money or whether there'd be an enforceable injunction still hadn't been settled almost a decade after the filing of the lawsuit. Same thing as with the Patent Office. Disastrous, unacceptable, intolerable. We've got to change that. We just have to change that. There also are other problems. Too much uncertainty, too much unpredictability. Business leaders all seem to say that what they hate worse than bad results or bad news is delay and uncertainty. And the uncertainty is huge. Or if you look at it from the standpoint of the level of error, the level of mistakes, whether it's by patent examiners or by judges and juries, it's unacceptably high. I would put the level of error roughly in the 20 to 40% range. If you ran a factory that made automobiles and your workers were producing a defective product in 20 to 40% of the instances, Could you stay in business? Would you tolerate that if you were the leader of the organization? I suggest the obvious answer is no. Maybe 2 to 4% would be acceptable, but 20 to 40% ridiculous. There are so many different measures of this, I won't go through them all, but just take the claim construction reversal rate. There's a little bit of dispute about exactly what the number is, and there have been all kind of law review articles, but by anybody's calculation, the number exceeds 25%. Most people peg it at 30 to 35%. My successor as the chief judge put in an opinion in a footnote that it was 50%. But whatever it is, somewhere between 25 and 50, intolerably high, totally nuts. We've got to change this. Now, what would it take? What would it take to fix the patent office, to take a almost dysfunctional agency and make it hum? Is it impossible? Is it unaffordable? Would it just be gigantic? Well, there's 7,000 examiners now. There used to be 6, and recently they've ramped it up to 7. I calculate that they would need somewhere between 10 and 12,000 examiners, 3 to 5 more than we have now, to make it work. This is entirely doable. You can find unemployed engineers and scientists all around this country and give them good, important jobs, and the country would be vastly better off. And then important patents could be examined in 2 years instead of 6, 8, and 10 years. It's doable. It's affordable. Even at the board level, they have 120 board members now in the appeals board. They've renamed it, but I'll just call it the appeals board. They need 150 more. So it needs to go from 120 to 270. Is that doable? Can you find the talent? Yes, they've already found the first 20 added board members, and they've gotten exceedingly talented people, including a couple of our former law clerks who made it big in private practice but wanted to help the country and were prepared to take a lower salary to do some very interesting, very important work. So the talent's there, just like the talent for examiners to expand the examining corps. It's affordable. The fees are being raised. They were raised last year. They're raised again this year. They're expected to be raised more modestly again next year. So 3 years in a row, fee raises on the order of about 25% total. Will give the Patent Office a lot more money. There's a problem of whether Congress will let them spend it, but that's another matter. I'll come back to that in a minute. But the money is there. The talent is there. The need is there. Why isn't it happening? We'll see. Maybe it will happen. It really needs to happen. And there are other things. Consider this. The Patent Office, maybe the CDC or NIH beat it, but the Patent Office is certainly one of the government's premier technology agencies. So you would assume that it would have very good IT systems, right? Wrong. It has the worst IT systems imaginable, equipment 25 years old, software horrible, databases totally inadequate. The system breaks down constantly. So you got 7,000 examiners working off a centralized computer system to do examinations. When it goes down for 1 hour, that's 7,000 hours of work lost, and it goes down often. It's a total disgrace. Why? Well, they've had various computer upgrade, update, expansion plans, which they've developed and redeveloped from 2006 right up to today, but they haven't been able to implement most of these plans. Why? Because they haven't had the money. Why? Because Congress took the $900 million to spend on pet projects or wherever it went. No one quite knows. And meanwhile, not raising the fees, but finally the fees are being raised. The money will be there. We can fix it. We can fix it. Now, in addition to IT systems, of course, the additional 3,000 to 5,000 employees need a place to work, or places to work. And by the way, I'm very glad to hear Atlanta's making a hard push to have this area be the location of one of the satellite offices the Patent Office is mandated to create. Detroit's the first one, and there are a dozen cities vying to have the other 2 current slots, and the Atlanta area would be a very appropriate one, in my opinion, and I think the opinion of lots of others. So I'm glad to see the leadership that you're providing to spearhead that effort. But whether it's in Atlanta or Detroit or in Alexandria, Virginia, You need places for these people to work. Do you know that 1/3 of the employees of the Patent Office don't work there because there is no room for them? So 1/3 of the examining corps has to work at home because there's no office space. They can't work where the Patent Office is in Alexandria, Virginia. And of course, the irony is great because who did they let work at home? Well, only the highly experienced examiners, because you couldn't let some rookie work at home without adequate supervision and so on. But that means if I'm a new examiner, a large portion of the people who should be my mentors aren't down the hall from me. They're working at home. And if we add 3,000 to 5,000 more employees to the Patent Office, where are we going to put them, whether it's here in Atlanta or Detroit or Washington? And speaking of Washington, the backlog and delay problems are so bad in the Patent Office that with the existing corps of examiners, many applications don't even get assigned to the relevant technology center, relevant art group, as it's called. That's patent speak for those of you who don't know it. When they come in, because they've found that if an examiner, varies a little bit by technology, but if an examiner has a caseload of more than about 90 cases, they just drown, they churn, they can't operate efficiently. So what they do is they hold back cases until the examiner with the right technological background has a space in his quota of 90. So what happens to those applications? Maybe you've represented inventors. This is a dirty little Washington secret, probably I shouldn't mention. But there is a warehouse in Alexandria, Virginia, and hundreds of thousands of patent applications, when they're filed, sit untouched, unread in that warehouse until there's space on the next train out of town. Again, a total disgrace. So Congress needs to provide IT systems that are modern, that are efficient, that don't break down, that have the right software, interconnectability, the right databases, and all the rest. It needs to provide the workspace, and then the operations, including the salaries of all the people in the Patent Office, can be maintained effectively by the new user fee regime. So the nearly $1 billion that the Congress siphoned off, it should have been investing in building space and fixing the computers. But we could still do it. So now, the blockade isn't really the budget. The blockade really is the congressional appropriators. Will they let Director Capos spend all of the increased level of user fees that now flow into the office week by week, month by month? So here's how it works. A lot of people know the phrase fee diversion. That was the polite name given to the thievery where Congress stole almost $1 billion over the course of 18 years of user fees. So people tell me, oh, I see that the new act ends fee diversion. But it doesn't end fee diversion. It pretended to end fee diversion, but those appropriators are very crafty people, and they don't like giving up power. So what they did is they said, we'll set a ceiling that you're allowed to spend at the PTO of the fees you collect. If you collect more than that figure, it will go into a reserve fund, and we won't give it to any other agency. We promise it won't go to any other use. And the legislation says this, so it can't lawfully go to any other use. But then the catch is this. You can't spend it without further permission from us, from we appropriators in the Congress. So that basically means that there's a serious danger that in fiscal 2013, the next fiscal year, it's okay for the current year, they're going to be able to spend all the fees they estimate they'll raise this current fiscal year. But next year, I think there's a high danger that there'll be a large amount of money that will spill into this reserve fund and that the Congress won't allow them to spend it. So that'll put us right back in the fix. So that's one of the things to watch. Watch the appropriators. Are they going to let Capos spend the overflow money, the excess money? Of course, it's not excess because every dollar desperately needed. Now, as I mentioned, the courts are funded by the taxpayers, so it's a little bit of a different problem. It is a legitimate part of the federal budget deficit and the national debt and so on. So what do the courts need? Well, It's, again, sort of scandalous, I'm sorry to admit, but for almost a decade now, there have been a permanent, steady state of 100 Article III judicial vacancies in America. Now, there are about 900 federal judges in all. So if 100 are permanently empty, that means you can do the math, 12%, 13%, something like that under strength. In addition to that, the last time the Congress passed what we in the judiciary called a comprehensive judgeship bill, meaning that matches workload with number of judges in each of the 94 trial court districts. The last time Congress passed such a bill, 1991. So we've gone more than 20 years without Congress reallocating the resources and increasing the resources and placing them where the greatest need is. Yeah, they've created a few judgeships here and there, particularly in the border states because of the immigration crises. But basically, where we are is we need 100 more federal trial judges in America. The money is there. It's not a question that we don't have the dollars. But every single judgeship in the United States, every Article III judgeship has to be created by statute, by an act of Congress. So even if you have the money, you don't get the judgeships. The judiciary is not allowed to create the judgeship based on need. They have to go to Congress and say, please add 3 judges in the Northern District of Georgia. But it doesn't happen because, as far as I can figure out, each party says, well, when my side controls the White House and my president will make the appointment, then we'll add the judges. And then when they change places, the other side says the same thing, so the judgeships that are desperately needed never get created. So 100 permanent vacancies, 100 needed judgeships that haven't been created, 200 short. So now we're at like somewhere in the neighborhood of 25% under-strength federal judiciary. No wonder the trials take so long. So the money's there. All you need is congressional action. It's another thing that the private bar, the private sector can and should monitor because it has huge consequences. Now, part of the reason I think the monitoring is so desperately needed and the input of men and women, whether you're in practice or at academia or at a think tank or whatever your exact role, you all have so much to contribute here, is that this bill, the AIA, as I say, has a lot of good things in it. I'm not an opponent of the bill, but I'm a critic of the bill because some of the provisions in it are totally terrible. And the whole way it was brought to birth was really quite unseemly. Basically what happened, just a little bit oversimplification, and this is just my own take on it, I'm not pretending it's entirely objective, and it's certainly not scientific. But basically what happened is the Fortune 100 companies, mostly large multinational companies, had certain problems they wanted solved. And they engaged in a massive 10-year campaign of lobbying and PR and campaign contributions to get the patent law reshaped to meet their particular beefs. And their beefs were legitimate, and they have a constitutional right to petition the government for redress of grievances, and every right in our political system to draw the attention of policymaking legislators. But what happened, frankly, was that the campaign was so heavily funded and so well organized and so persistent, with editorials being placed in all sorts of media year after year to change public opinion, congressional opinion, and all this money spent. There were something like 3,000 registered lobbyists lobbying on the patent bill. Can you imagine? One bill, 3,000 different people, and all sorts of unregistered lobbyists too. This is whole other story. But in any event, it was basically a PR firm, lobby firm heaven. So the product, the bill, largely reflects the needs, which I admit are legitimate, of those 100 companies. Well, what does the rest of the landscape look like? Well, in our country today, there are 30,000 companies that have at least 100 employees. If we go below the 100 employee level, the number is closer to 100,000. But there are 30,000 of that size, 100 or more employees. So the bill that caters heavily, not entirely, but heavily to the needs of the Fortune 100, underserved, in my opinion, the other 29,900. So the disproportion between who got served and who got underserved, huge. And if you take into account not just companies, but other critical institutions like the great research universities in this country, including Emory University, if you take into account the famous research institutes, Scripps, you name it, there are a whole bunch of them, they're very important. If you take into account small groups of inventors or individual inventors, they weren't really underserved. In my opinion, they basically were unheard and unheeded at all. Why? Because they didn't have huge lobbying firms and PR firms and planted editorials and massive campaign contributions. So they got pretty much ignored. So it's not only 29,900 who are underserved, it's a vastly increased number who basically weren't served at all in this legislative fracas. So some things in the bill came out really terrible. It seems that the Congress can't resist blatant bailouts for Wall Street. So a dozen Wall Street mega banks and huge investment houses were very upset about so-called financial business method patents. So they got a totally anomalous, wildly overwritten Section 18 put in the bill because they have so much money and so much political sway, they could get anything they want from Congress. So they did. So that's one of the worst features in the bill, in my opinion. It's retroactive. It will provide the potential to toss out patents that have been upheld already in re-examination in the Patent Office, have been upheld by the courts, were lawful when they were issued under the case law, but they may go down in flames anyway because Wall Street got a bailout. And then there's some major parts of the bill where the impact is very unclear. All these post-patent issuance proceedings, there are basically 4 of them, I guess, 5 of them, but the 2 most important are called post-grant review and inter-parties review. And the sleeper is that they continued the old ex parte, which is a one-sided, secret, potentially anonymous way to attack a patent. So if I were a predatory, vicious person, I would create a law firm that would attack valid patents by using what in football is called gang tackling, where you get multiple actual or potential defendants in an infringement suit, and you sort of take turns attacking the patent serially. So I file an ex parte re-exam, then Dan files a post-grant review, and then Brooks files an inter-parties review, and we put the patent under a 5 to 10 year cloud, and I'll come back to whether that time frame is exaggerated or not. But in any event, this set of post-issuance proceedings has a good upside. It will get rid of some bad patents. It may strengthen the legitimacy of some good patents, and so that's the upside. The downside is if it ends up, and who knows, putting a heavy cloud over the viability of a lot of patents, there's a risk that their value will go down, at least as long as the cloud lasts, which I say can be many years. If that happens, what's happening to investment incentives? They've got to go down too, I think. I'm not an economist, but I don't see how they can not go down if there's a serious cloud that lasts for years. So we don't know yet what the post-issuance proceedings are going to look like. But consider how ill-equipped the Patent Office is to do this. These post-issuance proceedings are the equivalent of a district court judge trial on validity. How many people in the Patent Office have ever been a district judge? 0. How many people in the Patent Office have ever litigated validity cases in front of a district judge in the United States court? That's probably also 0. So this is something they have no experience at before. They're having to create a whole litigation system. They issued rules, proposed rules, regulations a couple days ago, which basically create an analog to the federal court system with rules of procedure, rules about discovery, rules about sanctions, rules about motions practice and fees and all sorts of other stuff. Totally untried. It took the judiciary since the 20s to build the current civil litigation system we have in this country. The 1938 rules, followed by the rules of evidence and the appellate rules and so forth. It's not easy stuff. I think our discovery system is suboptimal, to put it kindly, but it took a long time to construct, and it's been very difficult to perfect. And the idea that the Patent Office can write regs and come up with a better litigation system overnight, maybe, but I'll be surprised. So they have no experience. They're creating a new system. We don't know if this rocket flies or not, but we'll find out. And if it doesn't work, we need to make some changes, especially if it devalues patents, which I think is the likely impact. So let me focus a little bit on a special type of economic actor, innovation entity that are sometimes called startups. Everyone knows about the, particularly people in Congress, about the 2003 report by the Federal Trade Commission. Very critical overall of the patent system as it existed at the beginning of that decade, which was the period under study. And everybody knows that the next year, the National Academy of Sciences National Research Council came out with a largely similar report, again, very critical of the patent system in operation, and again, based on how things stood at about the year 2000, 2001. So everybody knows about those two studies, and they're important, and I've read them, and I've relied on them, and they have a lot of good things in them. But by now, by 2012, they're badly out of date. And to an extent, I would suggest, they were overly ideological and somewhat biased because of the going-in assumptions used by the researchers. But what's really important is what is not on the radar. How many of you have heard of the study by the Census Bureau that came out, I believe, in 2009 or 2010, or the studies that have been done by the Kauffman Foundation into the importance of startups? Well, these two studies that none of us have ever heard of pretty well prove, I think, but you check for yourself, pretty well prove that for the last 4 decades in America, almost all net new jobs were created by startups. So if that's even close to true, then obviously the investment incentives, the IP systems, the financing has to work for startups if we're going to create the 28 million new jobs we need in a hurry, need desperately. So who are these startups? Well, they're usually defined as companies that are small but growing fast, or at least have the potential to grow fast, almost always less than 5 years old. Keep in mind, Hewlett-Packard actually literally was started in a garage by 2 guys from Stanford. This mammoth, huge, rich, successful corporation now. I use their equipment myself, so I'm a customer. I'm not a critic. But that started as a startup. And so did Google, and so did Apple, and so did innumerable companies in every technology. So whoever else the system has to work for, and it should work for everybody, every type of player, it especially has to work for startups. So when we try to evaluate the impacts of the Act, where is it working well, where is it not working well, we should be focusing heavily on 2 things: net new jobs created and impact on startups. Well, what do the startups need? Of course, I'm not a startup executive, but I've done some study of this, and I've spent a lot of time with some of these CEOs. And what they tell me is there are 3 critical stages at the minimum for these kind of companies. The first is to finance the important R&D that takes you from a bare idea to a commercializable product. I'll call that the R&D phase. That takes a significant amount of money, often in repeated doses. And it always has to come from outside, because Hewlett and Packard in their garage don't have any money. They don't have a revenue stream like IBM or Apple has. So they depend totally on outside financing. So can they get it? Will the venture capitalists fund them? Well, they did fund them, and we see the great results of that. But that's the funding that seems to be substantially drying up in Silicon Valley and elsewhere also. So that's stage one. Stage two is where the product is perfected, the market's been tested, and now I'm ready to build a factory that's going to produce these widgets, whatever it is, some life-saving medical device, let's say, on an industrial scale, produce 1,000 a week or whatever it is. So you have to build a big, expensive factory to do that. So you need a lot of money. So you have to go back to investors and say, okay, I did the R&D, I've got a great product, I tested the market, it'll sell like hotcakes, but now I got to build the factory, and you know what? I need $1 billion. Can you guys lend me $1 billion? And they say, maybe. Show us what we're going to get for it. Is the incentive there? We say, well, I got some patents. Well, are your patents in re-exam? Are they going to be put through these post-issuance proceedings? When will they come out the other end? Maybe I'll wait until then. Then I'll tell you whether I'm going to give you the money. And then it turns out the third stage is even more important. What's the third stage for startups? The third stage, I'm told, by people who are experts, is when they do an initial public offering and tap into the vast private capital resources available through the stock market. But it takes money to do the IPO. So who's going to lend you the money to do the IPO? So once again, the startup company, now growing rapidly, needs to go to outside funders. So same set of questions all over again as in stage one and stage two. You guys want me to invest $100 million? I've got the $100 million. Sounds like you got a real interesting product here. What's my guarantee I'm going to make money on this? Get a return on my investment. To a great extent, it comes down to, can you get a patent? Can you get a good patent? Will the patent hold up in courts? Will the courts be able to operate quickly and fairly and effectively? Will the patent office be able to do the same? So then we're back to what we've already discussed. Now, I have the view that, and I should mention that if you look at the job creation, when you're in stage one, very small increases in the number of jobs at the startup. When you go to stage two, of course, you build a factory, it starts to ramp up. But when you can finance the IPO, it spikes, because then you build 5 factories, and now you're employing hundreds, thousands, tens of thousands of people. That's why the job creation power of the startup is so important, but it totally depends on outside financing. So we go back to investments, incentivizing investments. Now, I said, and I'm going to wrap up shortly, but I mentioned that the timing is a big problem. Put aside the error rates. So these post-issuance reviews are promised to be done in a year, or at least that's the goal. Or at least that'll be the average. Or at least we'll try to make it the average. That's kind of the vacillating promises of the Patent Office. But if you look at the fine print of the law, the 1 year, not enforceable, number one. Number two, it's not a real deadline. Number three, it doesn't count the petition stage that precedes the start of the formal proceedings, and that adds 6 months. So the 1 year is really 18 months, but you know what? Even the 1 year isn't really 1 year because it's extendable to 18 months. So now we're at 24 months. And that doesn't count the appeal to the Federal Circuit, which adds a year. So now we're around 3 years for one proceeding. So if you have serial challenges to a patent, it's easy to see that you can be talking about a cloud over the patent that will last 4 years, 5 years, 6 years. Hard to know. Maybe it won't be that bad. Maybe I'm being too pessimistic. I hope I am. But the idea that these proceedings are guaranteed to be fast is a total joke. And the idea that it really is anything close to a year is also a total joke. And whether the protections against highly serial proceedings are adequate, of course, only time will tell. But if you own a patent and it's under a cloud for, let's say, 5 years, what do you think the prospects are that you can license that to anybody? That anybody will pay you for a license? Assume a valid patent for a great invention, lots of demand for the product. But you probably can't license it if it's under a serious cloud. How about selling it? Can you sell the patent to somebody? Maybe, but I wouldn't think the prospects would be very good. Can you exclude other people from infringing your patent? Well, that depends on a federal district judge. So here, the beleaguered 650 federal trial judges in America, swamped with immigration cases, swamped with criminal cases, required by statute to do the criminal cases before the civil cases, drowning in all sorts of other civil cases dumped on them by the Congress, which has federalized hundreds of causes of action. So the federal trial judges are hugely overburdened. So if I've got a big, difficult patent case, and the patent is in post-issuance exam, the temptation on me will be huge, almost irresistible, to stay progress in the case, put it on ice until the 5-year activity back at the patent office and all the appeals therefrom have been concluded. So that means you can't enforce your patent either. We're assuming a valid patent being intentionally infringed by somebody else who's ripping you off. But you may not have any remedy in court as a practical matter. In theory, sure, you can file a lawsuit. But if it gets stayed, it's kind of meaningless. Now, maybe there's some ways to fix that, too. Now, some people say, well, don't worry, because after the 5 years, your patent will be gold-plated. No one will be able to criticize it. But of course they will. When somebody gets sued for infringement, they'll defend by saying the patent's invalid, and they'll come up with some new prior art or some new defects in the patent and get litigated all over again. There's some estoppel effects, but they don't involve co-defendants, I don't think. So whether they're adequate or not, only time will tell. Now, I've talked a lot about the help that the courts need from you and the Congress, the help that the PTO needs from you and the Congress. But other people need your help too. For example, the Supreme Court and the Federal Circuit are very smart people. They work very hard. They know the doctrine. They know the precedents. They reason carefully. They write at great lengths. You see the results, and we all know all about that. But what don't they see? Even with the help of amicus briefs, which are a great boon to the work of courts, especially in such a practical area. I mean, patent law is instrumental. It's all a question of, does it work? You know, it's not like religion or philosophy. It's not right or wrong. It's, does it work well or does it not work well? Well, how would we know? How would we judges know? Supreme Court justices, Federal Circuit judges, how would we know whether it's working well at the ground level or not? Well, we mostly won't unless people like you who see it up close and personal tell us in amicus briefs, in all sorts of ways, articles, speeches, panels like you'll hear today, and so on. You can't imagine how important your input is to the courts, formal and informal. Amicus briefs, hallway conversations, articles, speeches, panels, the whole panoply of possible communications. Same thing with the House and the Senate, the members and their staffers, people in the Commerce Department, people in the White House. They need your help. They need your insights. They need to know, as the bill gets implemented, how is it actually working? What's working well? What's not working so well? What needs to be changed? How to change it? You'll know first. You'll know best. I hope you'll tell everybody. The media also needs a lot of help. When you read some of the articles, even in the great networks and national newspapers dealing with IP law, innovation policy, and all the things we're discussing here today, a lot of those articles are so badly informed. And then you talk to some of the reporters, they don't have a clue about how IP law works. And how could they? Usually, they've just been assigned to that beat 6 months before. They haven't been on the beat for 6 years. So they're in trouble. They need help. They need your help. They need my help. They need everybody's help. I think that private reform efforts, or I even want to call it re-reform efforts, because if the bill was patent reform, then the next stage will be re-reform. The private sector is going to save the country by re-reforming the IP regimes to work better. It's going to be done by people like you, individually, through law schools, through intellectual effort in articles and amicus briefs and all the rest, but also through various institutions. For example, the American Bar Association has an IP section, a litigation section, administrative law section. They can do important work. Many of you participate in that. The Intellectual Property Owners Organization is another important organization that files amicus briefs and does studies and so on. They can help funnel your insights in useful ways. Same thing with the AIPLA. You know, we love alphabet soup in Washington, American Intellectual Property Law Association. But there are other groups too. There is a little-known group called the Sedona Conference, which is largely made up of patent litigators and a few industry people, but very smart, hardworking, generous people spending a lot of time trying to improve the law of damages by coming up with new doctrine to replace the perfectly inadequate so-called Georgia-Pacific case. That's an interesting case. It's a laundry list. It was never intended to be a formula. It was a laundry list of every damages theory ever used theretofore. This is a 1970s case. So it was just a catalog of what had been used in prior decades, but somehow it's ossified into rigid doctrine that damages have to somehow or other be calibrated under the 16, I think it is, conflicting, overlapping, unclear Georgia-Pacific factor. But we can do better than that. Sedona Conference is trying. Other groups are working on expanding the use of mediation and arbitration in intellectual property cases because it'll be faster, probably will be just as accurate, maybe better. It will be vastly less costly. I'm doing a lot of that in my new life myself, mediation and arbitration. It's very interesting and very challenging, especially in IP cases. And the last thing I want to mention brings us right back to home, right back to probably the greatest single resource, in my opinion, in America today, which is the American Research University. That is the best engine we have for forceful innovation that can drive prosperity and job creation and health cures and all the things that we need. But it's not happening despite all the good work, professors who work with business people and finance people to commercialize products that come out of their research work. A lot of good work is being done, but it needs to be vastly expanded. In many parts of the country, including here, I'm told, which I'm thrilled to hear, there are now evolving wonderful networks. I'm participating in one as just sort of a lab experiment in Northeast Ohio, where a handful of research universities, local colleges, community colleges, business people, finance people are all banding together, to try to come up with a sort of a regional Northeast Ohio optimal ecosystem to promote innovation and the job creation and prosperity and technological leadership and all the other things that will flow from that. I think these efforts can leverage the existing great work of commercializing the discoveries of scientists and engineers and other researchers at the great universities on a vastly escalated scale from what we've seen so far. So that's one more way that all of you can help by becoming participants in these sorts of networks. So there's a lot of potential. There's a lot of upside. There's no downside. It's only a matter of will and investment. In your case, not of money, but of talent and time. So I hope you'll join me and many others in doing so. Thank you so much for your kind attention.
Do you want to take about 5 minutes? You want to take some questions? Do anyone have any questions you'd like to ask? We got about 5 minutes before the break.
Yes, sir. Well, it's out in these proposed regulations. There are various blogs and publications rapidly analyzing it. The fees are quite high for everybody except small entities and micro entities that get a huge percentage break on all of these fees. So it depends a lot on the size of the player in the system, but they're on the whole quite expensive. Good part of that is more money for the patent office that needs more money. Bad part is if it suppresses innovation and invention in a material way, that's a heavy price to pay. But the fee structure is out there in public now, and it looks pretty daunting to me. It looks like pretty high fees, and I hope it doesn't have negative consequences. Other questions? Don't be bashful. Yes, sir.
The question really is why. I hear that the patent office, the beast is being starved. And broadly, is that because of factors unique to the patent system, or is it simply another illustration of the broader economic problems? maybe put differently, is there any specific problem that is holding back the political will to improve the patent system?
Well, yeah. I spent 9 years as a staffer in the Senate in an earlier stage of life. It was a very educational thing. When I was a staffer there, the senators, almost every one of them, spent about 1/3 of their time raising money, getting press, touring the state, conducting town meetings, and otherwise trying to get reelected. And they worked like hell the other 2/3 of the time on trying to solve the problems of the country and move us forward as a society. My impression, I'm not there anymore, so now it's secondhand, but my impression is now they spend about 90% of their time trying to get money and press and get reelected, and about 10% of their time trying to solve the problems of the country. They had a saying, even when I was at the Senate way back in the 80s, that money talks, early money shouts. So what happens is, the minute a member gets elected or reelected, they start fundraising right away. Why do they do that? Because most of the districts are safe districts for the one party or the other. So if you win in your primary, you're almost guaranteed to get reelected. So how do you win in the primary? You raise so much early money that no strong challenger is willing to step forward. So then you automatically win the primary, then you automatically win the general election, then you're a congressman for life, or a senator for life, or nearly so. So I think the problem is that the focus of the members is so exclusively on these re-electioneering imperatives that something that doesn't give them big campaign contributions, big press, just gets lost in the shuffle. They don't want a bad patent office, but it just doesn't rate on the priority list because they're focused on so many other things. Same thing with the White Houses. You know, the fact that there are 100 judicial vacancies isn't just because the Senate's slow and inefficient and irresponsible, which it is, but it's also because the White Houses, under both recent administrations, have been equally bad. They don't make nominations promptly. The Judicial Conference policy is you're supposed to tell the president 6 months or more in advance that you're going to be leaving, retiring or taking senior status. Either way, it creates a vacancy. So a lot of judges do that. I did that. My seat still hasn't been filled. I left 20 months ago with 6 months prior notice. So 26 months they've had to fill my seat. Hasn't been filled yet. White House is too slow, Senate too slow. The White House and the Senate don't want a bad court system just the way they don't want a bad patent office. But the problem is they just don't focus at all on these things because they don't translate into massive press and campaign contributions and re-election potential. So what you have to do is you have to recruit a few champions in the House and the Senate, which is doable, and you have to keep them and their staffers well informed, and you have to get them to then convert enough of their peers into caring about these vitally important American institutions like the Patent Office and the court. So it's possible to do, it's hard to do, it's an uphill battle because now everything's just a big race for money in Washington, D.C., I'm sorry to say. I've very much enjoyed the questions, the chance to be with you. I hope the rest of your day is very productive. I'm going to have to leave before it's over, but I'm sure looking forward to the first panel. So again, thank you very much.
I just want to say that while we appreciate your many years of service on the bench, I'm glad we got you here after you retired so that we can hear what you really think. Very enjoyable. I think the Judge really touched on a lot of the themes we're going to be going deeper into today in our panels. For now, we're going to take a 15-minute break. Please enjoy the snacks and drinks in the lobby, and we'll see you back here at 10:30 for our first panel.